good results. But although the government had a detailed a detailed evaluation study done, it did not release that study. It released a very manicured, glossy brochure from the Department of Justice reporting second-hand on some aspects of that study. So the community is not in a position to make an informed decision about it, but the crucial question we have to ask ourselves is what has worked in the Neighbourhood Justice Centre, what can be migrated to other courts around the state. Are there aspects of the Neighbourhood Justice Centre which are not justified by the cost that's been involved in delivering them? We can't make that sort of judgment unless we can see a detailed evaluation. It's not just to continue the way it is at present indefinitely.
But philosophically, you're not opposed to separate courts catering to separate groups of people who have particular needs?
I'm not opposed to having programs including potentially different court lists that deal with people having different needs. I mean, that's been something that's existed in our court system for a long time. Different classes of cases go into different lists. Our side of politics was very supportive of the court assessment, the assessment referral court list. Indeed, we were critical of the government for not making adequate provision for people with intellectual and cognitive impairments. But that's starting as a trial in a small number of courts. You can't justify that sort of facility being available in some courts but not others indefinitely. If the trial works, you've got to find a way of generalising it, so if you're in Horsham or Sale or Broadmeadows, you can get the same access as someone who's referred to the Melbourne Magistrates Court.
But Brian Walters, philosophically, what's your position on these courts which cater to different communities or different people with different needs?
Well, philosophically, I'm in support of evidence-based solutions and front-end loading our justice system to do as much as we can to prevent crime, for example, or to prevent recidivism as we can. Now, we know on the evidence, for example, that the Koori courts have been a great success in this respect. We've got young Koori offenders who need to take responsibility for what they've done, coming before some magistrate often doesn't mean nearly as much as coming before their own elders. And we know from the experience we've already had that the recidivism rate from the Koori courts is a lot lower than it is from the traditional courts. So that's a great advance for us. Now, not all cases are going to be able to be resolved in this way, and there are limits around these programs. But I think being creative in thinking about the justice system, thinking of ways that are going to prevent repeat offending, and keep people as integrated into the community as possible is really important, because people offend and need to take responsibility for their offending, but they offend in a context, never in a vacuum. So there might be issues of homelessness or mental illness, whatever have you, and there are special needs and requirements in those circumstances. And a specialist court dealing with that can often be the cheapest solution in the long run and the fairest solution.
Brian Walters, do you think that the current level of legal aid funding is adequate? And if not, how would you expand it and how would you pay for it? I'm a lawyer. The current level of legal aid funding is pathetically low. It's, in criminal cases, it's a significant compromise, like it's a fraction of what the commercial fee would be for running the case. There just isn't enough money to go around, and there's an increasing demand. In terms of civil remedies, indicating the rights in civil claims, it's non-existent for all practical purposes. And if we're serious about the rule of law, we have to make access to justice a part of that, or it's the rule of the powerful. Well, you're a lawyer, you're a politician. resource allocation issues are at the top of your priorities, I imagine. What do you reckon? Do we spend enough money on legal aid? And if not, how would we pay for it?
Well, legal aid is certainly very stretched at the moment, and it is something that we should aim to increase. Now, I'm not making a policy commitment to do that. I'm saying that's an aspiration that we should be working towards. I can say that from our side of politics, we've got no intention of raiding the public purpose fund the way the current government has, which depletes funding available for legal aid. We want to wind back the draw on the public purpose fund over time, and we certainly were strongly opposed to the attempt by the government to raid it to fund the cost court, which should have been funded out of mainstream budgetary allocations, and thanks to the non-government parties in the Legislative Council, that was the result that was achieved. But there is huge pressure on the legal aid budget at present, and that's been allowed to decline over the course of quite a few years.
So you aspire to spend more, but you're not telling us how much?
I'm afraid I'm not in a position to make policy commitments tonight, Damien, but I am accepting that government should be aiming to increase the funds available for legal aid as that becomes possible.
Let's now talk about the new police search powers. The stop and search powers proposed in the Control of Weapons Act include provisions which will allow the search of children and strip searches. Are these powers appropriate, Robert?
Well, generally speaking, we've been supportive of the increased police powers to search for knives. As they stand at present, they are not powers that are possessed by individual police on the beat. There's a conscious policy decision within the police force that there will be searches in a particular area. Obviously, they're searching primarily for knives, which have proved to be a huge social problem over recent years. I think given that when we go into just about every second public building around Melbourne, including into courts, visitors to Parliament House, etc., we're willing to subject ourselves to being searched for the sake of assuring public safety, and likewise, of course, at airports, the ability of police to carry out searches in the way they're empowered to for knives seems reasonable. Now, that's not to say you give police total open season. You obviously expect police to exercise those powers in accordance with the purpose for which they're given, not vindictively, not in by way of persecution, but bona fide for the purpose of trying to ascertain whether people are carrying knives or other illegal items.
But you're satisfied that they should have the increased powers, and you'd give them the benefit of the doubt until they cross that line?
In broad principle, we are supportive of police having the powers to search for knives and other illegal items, subject to that being conducted fairly and in accordance with the law.
Brian Walters, what is your view of these new stop and search powers?
In the 2 years leading up to the passage of these powers, there was a decrease in the incidence of crimes in which knives were either used or brandished of 2.9 or was it 3.9%. So a decreasing knife crime. There is no evidence at all that random police searches reduces the incidence of knife crime. There's none. If you're serious about public policy in this area, it must be evidence-based, and there is no evidence that this would help. Now, the government admitted as much in the second reading speech in May when the Minister said that it was being introduced because of public perceptions about knife crime. What these laws do is allow not just searches, but random searches without any requirement for a reasonable suspicion that you've got a knife or a weapon. So you have a situation where the power that is given to search, and as it's been pointed out, includes strip searches of children and disabled people. Those powers